Hi everyone, welcome to this Expert Voices seminar. My name is Vicky Morris and I'm the Deputy Director at the Centre for Justice Innovation. I'll start by saying a little bit about the Centre. So we're a not-for-profit organisation that seeks to build a justice system which every citizen believes is fair and effective. We believe the justice system should be focused on solving the issues that drive crime and social harm, and that it should be fair in how it treats people. And we deliver a range of work to achieve that vision. So we provide hands-on support to practitioners. We conduct research into how things work right now and how they could work better in the future. And we promote evidence-based and innovative justice policy reforms. So the Expert Voices seminar series is at the heart of the approach that the Centre has. And this is our fourth in the series, and you can access our previous Expert Voice events on our YouTube, and we'll send a link in the chat in case anyone's interested in watching those. So the Expert Voices event series seeks to discuss key issues affecting the justice system, and it is free and open to everyone. So we aim for it to be accessible to people from a range of backgrounds and prior understanding. And it is part of a much wider programme of work that we do at the Centre to promote the voices of both practitioners and academics who are leading on crucial issues that are cut across the justice system. It's linked to a range of blogs, also titled Expert Voices, and to our map of innovation, which charts innovative projects happening across the UK's justice systems. And we'll pop a link in the chat to both our map and our blog pages in case you're interested in having a look. So firstly, just to go over some housekeeping before I introduce our speakers. So your cameras and mics are turned off. That's just so we don't disrupt the speakers, and the session is being recorded so that, as I said, we can later put it on our YouTube channel. There's a Q&A function which I'll talk about in a little bit as well, so please do throughout the presentations be putting your questions, and we will come to those in the second part of the presentations for the Q&A session. So today's seminar is focused on the impact of the recently announced presumption against short sentences for women. So for context, on the 16th of October, the Right Honourable Alex Chalk, Secretary of State for Justice, announced plans to legislate for a presumption against sentences of 12 months or less. And this is in response to growing concerns over prison capacity. And we are very privileged today to have two excellent speakers who will speak for roughly 15 minutes each, so leaving ample time for Q&A at the end. So firstly, I'd like to introduce Dr. Shona Minson from the Centre for Criminology at the University of Oxford. Shona is currently a British Academy Research Fellow with an interest in maternal sentencing. And Shona will share her insights into how short sentences can be particularly detrimental for women, as well as the disproportionate number of women receiving custodial sentences of less than 12 months. And I'm also delighted to introduce Fiona Deacon. So Fiona is the strategic lead for women for Greater Manchester's Probation Service. And Fiona will use her experience as a senior probation officer in Greater Manchester to discuss the alternative options to short custodial sentences and how women can be better supported on community orders. So we have a great lineup to discuss the impact that presumption against short sentences could have on women, and we hope you enjoy. After both Shona and Fiona have spoken, I will open up the Q&A. So a reminder, you can type your questions throughout the talk in the chat box, and please state your name and where you're from as well. So without further ado, I will ask Dr. Shona Minson to start with her presentation. Thank you.
Thank you very much, Vicky. It's good to be here. Thank you for inviting me to take part in this. So I'm going to talk for about 10 minutes about some background to women's imprisonment, and then really trying to unpack what this presumption is about and what might happen with it before handing over to Fiona, who I've had the huge privilege of working with over the last couple of years. I'm sure many of you are so familiar with this, but just in case we're not, in 2022, about 5,000 women were in prison in England and Wales, and that is twice as many as 30 years ago. So we've had a huge increase in women's imprisonment, despite there not being a corresponding increase in crime committed by women over that period of time. About 69% of women in prison on sentences are therefore non-violent offences. And I want you to bear in mind that what it says in the statutes is that prison is reserved for the most serious and dangerous offending and offenders, and it is where there is no other sentence would be suitable. Of the women in prison who've been sentenced to immediate custody, 53% are thought to have been sentenced to less than 6 months, and they will come out of prison in half of that time. And actually, the number that are in for less than 3 months is a shockingly high percentage as well. So we have women who are going into prison for matters of weeks. There's an additional 13% who are there from 6 to 12 months. In case you're wondering where these stats are coming from, I refer you to the Bromley briefings this summer 2023, where actually they put together all the MOJ stats on this, and it's an incredibly useful resource. So thank you to the Prison Reform Trust for that. So in the time where we've increased the number of women in prison, community sentences have dropped by about half in a decade. And it's worth also just giving you a bit of context at this point that only about 3% of all sentences for women are suspended sentence. So at the moment, that is a very underused sentencing option. So when we talk about what this new development in the sentencing bill looks like, it starts from a premise. The government has said no prison system should further criminalise offenders, and we must be focused on ending the merry-go-round of reoffending. And they're absolutely right. There is this merry-go-round of reoffending. We know that 55% of those with short sentences are reconvicted. If it's been less than 6 months they've spent in prison, that goes up to 58%. Suspended sentences, the government's own figures are 24% reconviction rate, and we know it's also lower with community sentences. So there has been this realization that actually sorry, just got thrown there by something popping up in the chat. The government have recognised that they cannot continue as they are, and part of that is about prisons being overcrowded. That's been the rationale. The rationale is efficiency. So if you look at the government's own documents about why this is happening, they say the current sentencing framework is leading to inefficiencies in terms of substantial economic and societal costs resulting from high levels of offending. So we've hit the point where money has become the issue, and that is why we're seeing some change. So there are costs at the moment because of this reoffending rate. And so the government's stated objective in this presumption is to reduce the current levels of offending and ensure the effective use of the prison estate. Now, in addition to that, what they've said is that this presumption, which is that all short sentences of less than 12 months will be suspended, is intended to highlight to the court that short sentences of immediate custody should only be used as a last resort, and alternative disposals should be used whenever possible. They go on to say this option will aim to ensure a diversion from custody as the primary aim of judges and magistrates when considering sentencing decisions for those who would otherwise receive short sentences of immediate custody of 12 months or less. So how would this work? Well, they would first of all, a judge or a magistrate has to get to the point of deciding to pass a custodial sentence. They have to have decided that community sentences are not appropriate, and this offending is so serious that only a custodial sentence is appropriate. So they have to do the calculation and say, well, it would have been a 3-month sentence, and so therefore I know I have to suspend that. So I am going to give this person a suspended 3-month sentence. And that sentence can be suspended for up to 2 years. Now, they have to do that unless, and there are many exceptions, so unless there is a significant risk of physical or psychological harm to someone if they are not put in prison, or if it's because of a breached court order or reoffending on licence or post-sentence supervision, or finally, because there are exceptional circumstances which would justify not passing a suspended sentence. So there are actually a lot of circumstances in which this presumption will not apply. And I refer back to, if you weren't at the last Expert Voices session where Professor Cyrus Tartar spoke, and I would definitely recommend listening to that again. He was talking about the way this has been done in Scotland, and that actually we've got a continuing problem that as long as there are exceptions, as long as we continue to have prison there on the list, as even if it's as a last resort or unless it's exceptional circumstances, it will continue to be used. So this is not actually prioritising diversion from custody. This is continuing to regard custody as a legitimate option. Now, the government have looked at the costs, risks, and benefits of these, and I don't have time to go into them. But what they have identified so far, I would say accurately, are that there's likely to be increased probation costs from supervision of people on suspended sentences. There are also likely to be higher breach rates of suspended sentence orders. Now, currently, those are breached at about 20% is the rate. But of course, the decisions made to give suspended sentence orders are made very carefully about people who might otherwise be in custody, who are not suitable for a community sentence in the view of the judiciary, and they are people who it is thought are unlikely to breach them. So we would expect it to be a higher breach rate if there is not discretion in that for judges. There's also a risk of up-tariffing, that people perhaps in the 9 to 12 months sentencing bracket will just be given 12-month sentences or upwards so that they don't have to be suspended. And we're also going to be looking at longer periods of post-custody supervision and sentence. So at the moment, the average length that a suspended sentence lasts is 19.7 months. I don't understand the 0.7, but that's what the impact report says. So it's likely to be similar, and it could be up to 2 years. And there's no reason to think that that maximum length will not be used. So at the moment where somebody is, for example, given a 3-month sentence, they then have 12 months of post-sentence supervision, bringing them up to 15 months. With suspended sentences, it's quite possible that that period will be much longer. Now, there is a recognised benefit, which is that community-based orders are less disruptive to the lives of offenders. I'm quoting the government report, and this option will allow more adult offenders to maintain important relationships, their livelihood, accommodation, and any treatment they may be receiving for mental health or substance misuse. So although this is being driven by efficiency and cost, there are, of course, benefits. So the question that I sort of pose is, well, is this a good idea? And my answer is yes and no. So yes, to stop using sentences of less than 12 months for women, or frankly anyone, is a good idea. I mean, of course, up-tariffing is an issue, but on the whole, it is a good thing. And in some ways, that's almost a non-question. We have the research evidence. It's well understood that short prison sentences are costly and harmful. And if we go back with women to the 2018 female offender strategy that many of us were around and working in this field at that time. And it said we'd like to see fewer female offenders sent to custody for shorter periods. To address the prevalence of short custodial sentences, we're putting in place a number of measures to foster an environment that encourages the use of community sentences instead of custodial ones when appropriate. Now, very disappointingly, that is not what has happened. And very few of the recommendations in that strategy have actually come to fruition. But nobody, I think, across, I'd be very surprised if anyone was disagreeing with the idea that actually we need to stop sending people to prison and we need to stop sending women to prison for these short times. But I'm not convinced that saying suspended sentences are the answer is the way forward. Because if an immediate sentence of imprisonment is not the right thing to do, then we should do something else. So in terms of suspended sentences themselves, I think they are a useful sentence in the right circumstances, but I don't think this presumption that short sentences should be suspended is the right way. So just giving some examples, my work is focused on maternal imprisonment, as Vicky said, and I've been heartened over the years since I produced various training resources for the judiciary that on a number of cases where a woman has been facing a prison sentence, usually over the 12-month mark, but under 2 years, a decision has been taken to suspend because of the impact a custodial sentence would have on her dependent children. And I recall one such case where that decision was in fact referred to the Court of Appeal as being too lenient. In that instance, there was a 2-year-old child. The mother and father were both convicted of drug-related offences. The father was facing a long term of imprisonment, and the mother's role had been lesser, but guidelines suggested she should receive a custodial sentence of 18 months and upwards. And the Court of Appeal said that when balancing the impact on the dependent child, it was appropriate to suspend her sentence. So I think suspended sentences have a place and should be more used, but I don't think they're the right tool in this circumstance. Because we need to look at what the purpose is. Now, if the government is saying the rationale is efficiency and the objective is public protection, then we're looking for effective ways to prevent people from being criminalised or from reoffending. And if we think specifically about women, for many women, what needs to be addressed are the factors that have led to criminogenic behaviour. And even when the offences are violent, and I've been doing court observations, some actually in Fiona's problem-solving courts and some in Scotland, but one of the most common ways assault offences seem to occur, and this is not proper quantitative data, this is just an observation I've made, is that a woman will be upset about something, and often under the effect of drink or drugs, police or emergency services come to deal with it. Sometimes the woman herself has called them because she is concerned about her own behaviour. When they try to talk to her, someone touches her and she kicks or hits. And it's a trauma response, a fear response. She's arrested, she's convicted of an assault charge, and we see the consequences come out. So what we really need to address for women to stop them either being criminalised or from reoffending is the factors like housing and addiction and relationships with their children and poverty. And again, I'm not sure that unpaid work, curfews, restrictions, and supervision in a punitive way, which is what we might see under a suspended sentence order, are going to be the best way to do that. And I think that problem-solving courts, places where people are supported for a period of time to set things onto a different trajectory, are perhaps one alternative that could be looked at. If we're trying to look away from saying that a suspended custodial sentence is actually a better choice. And with that, I hand over to Fiona.
Thank you very much, Shona. Gripping as always. Every time I hear you talk, there's so much food for thought, so thank you for that. So yes, I am going to talk a little bit about Greater Manchester. It's where I'm located. And what we have in Greater Manchester is a whole system approach model for women. And so as the strategic lead for women across probation, I've got the responsibility at looking at the options that we have for women when they're sentenced through the court. So thinking about women that are suitable for a problem-solving court, which is our alternative to custody model that we have. But then also looking at what we would have in the community for generic sentences, if I can call them that. So what the interventions look like. Do we have women-only safe places? And then for those women that are returning to Greater Manchester from custody, because we haven't got a women's prison in Greater Manchester or an approved premise for high-risk women, what does resettlement look like, and how do we support community integration and essentially reduce reoffending? And that in itself pretty much describes what is the whole system approach from the criminal justice point of view. But it's a lot broader than that, and it's a lot broader than the criminal justice system in Greater Manchester. So the whole system approach involves a number of women's centres and health partners, children and family services, and we all sort of sit under the umbrella of the local authority. We've got the Greater Manchester Combined Authority. So it does mean that we can look inwardly at the criminal justice system, but also look a bit broader at outer court disposals, early intervention. And we have some really strong pilots that run, some that are sustainable, some that don't last. It depends sort of like the political interest and focus, but it does give us quite a good foot in there to keep developing options for women. And it's a really long journey to develop a whole system approach. And every time I talk about it, I kind of reflect on how long it can take. And sometimes it can feel quite person-centered, person-focused as well. But what I want to do is just give you a bit more of an overview of what we have in terms of the criminal justice elements that I've got the responsibility for. And for me, it started as a practitioner. What I observed is what Shona has described there in terms of women just having just such a disparity in sentences that are passed. So it didn't seem to be enough sentencing options, but also real struggles with women to attend and comply. So for me, I focused on looking at the sentencing options available. And, you know, I did have concerns about, are we seeing women that are sentenced to short custodial sentences because they're seen as doubly deviant? Like, what is going on there when women are coming into the courtroom? And it wasn't uncommon to see a man and a woman in court for the same offence, and the woman would go to custody for 6 weeks, and the man would get a really robust community order with drug testing, curfew, programme, all sorts of things. So when you unpack what there is in the community for women who are a minority group of the criminal justice system, there wasn't a great deal there. If a man had committed a violent offence, probation in court could assess his suitability for 4 different types of programme to address that. And for women, it was called the Women's Programme. And it was a one-size-fits-all, and it was a bit longer as well than any of the other courses that were run for men. So the playing field wasn't exactly even. And when I spoke to sentencers about it, what they viable options sooner than men. So if you are continuously offending because of the social issues behind the offending behaviour, because that isn't changing, your sentence has to become more onerous each time you present in court. So women were reaching the custodial threshold a lot sooner than men. So I think many sentencers have already felt like it was a last resort for women, and really what they were looking for was another option. So that led to the response to that was developing the problem-solving court as an alternative to custody for women. It's 10 years old this year, and there are various models out there. There are lots of good practice now, lots of sort of areas that are looking to develop similar models. But what we have is a generic community order with the addition of reviews. That's what makes it a problem-solving court approach. And the reviews involve the women returning to court to speak to a dedicated bunch of sentencers about their social needs, about their lives. They develop relationships, and they have motivation and support to continue to address the issues that they presented with when they came into court for the offence. So that was kind of the start of looking at the disproportionality of sentences, but there was still something around the actual attendance for women as well, particularly when women are on a suspended sentence order. And although the statistics are quite low, it sometimes feels like there's such an overrepresentation there and a disproportionate use already. So I do have some concerns about if we were to see that increase, what would that look like? Because if you don't comply, if you don't show up, if you don't come in for your appointment, there's very little anyone can do really apart from take the order back to court. You're on a suspended sentence order, quite likely to go to custody. And walking into a probation office can be quite intimidating. Not for everyone, but for a lot of people. And if it's in your community, you might not know who's going to be sat in reception. You may be a victim. You may be a sex worker. You do not know who's going to be in there when you walk in. And what we needed was quite clear for me. We needed a safe place for women to carry out the sentence. So the sentence has been passed. It shouldn't be an extra punishment to show up and complete your sentence. So in response to what women were telling me about the reasons why they were not coming in and having their suspended sentence orders activated, we brought in women-only safe spaces, women-only reporting times, and it improved attendance and compliance. That was then uplifted out to the women's centres. And this is where we came together, and sort of back in 2017 at this point, where you had then the Greater Manchester Combined Authority, the women's centres that we were already hugely reliant on to support women with their welfare needs, coming together to form the whole system approach, looking at criminal justice, but also women at risk of entering the justice system. And the women's centres themselves formed an alliance. So they were a network of women's centres already that existed in the community, not there because of the criminal justice system, but there because it was the right thing to do, to have some support for women to go to for whatever needs they had. And what we found that by the centres consolidating themselves, they were able to come together. There's co-commissioning, co-design, and then we can co-work, co-locate, and capture outcomes. So that's over a long period of time, but where we are today is that we've got the lowest reoffending rate for women in England and Wales and Greater Manchester, which is great. 15% for Greater Manchester, 21% for England and Wales. And that feels really good. It's great on paper, but what isn't great is that we're actually putting a bit of sticky tape over the social issues and the social injustice that a lot of the women and the young people that we see are bringing into the court arena anyway. So I think it's fair to say there's quite a lot of us who are inside the justice system and we're pushing out for change. And there's an awful lot going on in other areas. And I'm obviously just focusing on Greater Manchester. So I'm just going to give you what is like a step-by-step journey for a woman coming through the court today in Greater Manchester. And then I'll hand over to Shona, who can talk about it a bit more like broadly around other parts, other good practice. So what we are offering for a woman is that at the time of the court appearance, she would be interviewed by a woman doing her pre-sentence report, and they would consider the problem-solving court if she's at risk of custody or a high-level community order. And then within that, they'd also consider all the requirements that we generically have within probation. At sentence stage, or even when we're looking at someone who has been sentenced to custody and returning to Greater Manchester, we have our inductions at the Women's Centre. So we have a bit of an opt-out approach now to having support through the Women's Centre. We've turned it on the head a little bit and made the assumption that it'd be easier to walk into a Women's Centre and choose to not continue than to find your way to a probation office and then find your way to a Women's Centre. So we give the women a lot of choices. We don't assume every woman wants to be in a women-only safe space. And what we'd offer the women is the choice to co-work alongside probation and the non-statutory support from the Women's Centre. And that works quite nicely when we need to look at things like the statutory side of things, like enforcement and warning letters. That sits with probation. The Women's Centre support staff can then really build a relationship with someone and get to the root of some of the issues. Anything that the woman is required to do as part of the order, so whether it's community service or a programme, in most of the centres, we've got placements there to support that. So we're keeping everything in-house. And then there's all sorts of other activities that that woman might want to join in with as well. In all but one centres, the woman could continue to stay there if she wanted at the end of her order for future support. They were there before the justice system, they're there after the justice system. And I think a lot of the women, if they'd found the centre first, probably would never end up with us in the criminal justice system. And we see women go on to become volunteers and mentors as well. So just before I hand back to Shona, I just want to make the point of saying, because it's very easy for me to brush past this, but for some women, custody is inevitable, and we know that, and we're really realistic about that. And I equally value public protection just as much as I value supporting women. But when it isn't inevitable, and that's the guidance that the court can give us, I'm not quite sure why, if it isn't inevitable, why it's even an option. So Shona, I'm going to come back to you and you can remind me of what else is going on out there in the bigger picture.
Okay. Thank you, Fiona. Great to hear all of that. And I think that is the question. If custody is not inevitable, then why is that even sort of on the table in the way this presumption is going to operate? So in my last couple of minutes, I just wanted to raise some bigger questions, I suppose, about gendered punishment and about why we keep doing what we're doing. So at the moment, the money is being spent on punishment and risks are being taken in punishment. The risk of people reoffending, the risk of more harm being done, the risk of families being broken up. There's always the risk that punishment will be effective, that custody might change somebody's life for them, but we tend to see the risks going in the opposite direction. So I suppose the question is, why aren't we taking risks in a different direction? Why do we keep putting money into the same types of services that we know have these risks attached to them? We can't be sure of what's going to happen if we do things differently, but maybe we could try. And there's no greater loss probably than the loss that is already suffered sort of publicly by the harms that we do by imprisonment, if that's the concern. So I just wanted to talk a little bit about women's problem-solving courts in different places that I've been looking at, because they all run on slightly different models. And I think it's important that as we start to think about alternatives, that we really are digging into what these are and what the purpose of them is within justice, within the legal system, with what's going on. And it'd just be interesting with the audience here today as well as to what your thoughts are about what might be effective, what might not be effective. So as Fiona said, in Greater Manchester, there has been a sentence and the woman is given her community order, but sentenced to the Women's Problem Solving Court. And the hope is that she will turn up every month. And having sat in that court, it's quite amazing to see what encouragement looks like in criminal justice, but even inside a court, because courts don't tend to be very encouraging places. But hearing women being asked, you know, did you get your housing sorted this month? Or even somebody saying, I mean, there was one occasion where this woman was an addict and she had managed to reduce the amount of money she was spending on her drugs from something like £120 a day to £40 a day. Now, of course, you're immediately thinking, well, where is she even getting that money from? Who's exploiting her? What's happening? What's going on? Nobody criticized her. She was just told, well done, that must have been hard. You're making progress. And that is a really different shape for justice to take, and from those who would normally be punishing and sentencing to do that. So there's that model that's going on in Greater Manchester and is clearly having effects. In other places, so I've been observing the Female Offenders Court in Glasgow, and there it is a structured deferred sentence. So a woman is brought to court, she's convicted of an offence, and then instead of being sentenced at that point, she's sent for consideration as to whether the Female Offenders Court is the right forum for her. And if she's so there's actually a hearing for that, and if she is thought to be suitable for that, and the idea of that is she has problems that need solved and that this forum might be able to help her with, she will then be accepted into that court, and she then will be coming back for reviews in that court. No sentence is actually passed. What she does is she meets with criminal justice social workers who take on the role that Probation take on in England and Wales, and they will design a plan for her. They pair with Tomorrow's Women, which is a women's centre, and the woman will have all kinds of sort of inputs, or things will happen if she engages, and the key part of that is engagement. Now, she can, at that point, at the end of her time, and again, it's very undefined, she may be given actually no further punishment. So there is in fact not a sentence passed, as it were. She has her time in that court and then it ends. She's dealt with the issues that have led her into offending. She hasn't reoffended and she's free to go. Other women may actually be referred back for sentencing to the original court. And in some cases, that will have been seen as a time to help them stabilise their lives sufficiently that they'll be able to have a community sentence and comply with it, and it has prevented them from being sent to prison. So there are all kinds of different uses that can be put to. And then we've got other other models in other countries where it's in fact a deferred conviction. So somebody comes before the court, and before they're actually found guilty or plead guilty, they are sent to the problem-solving court, or whatever way that is operating, where they will again have their needs addressed, given a period of time to see what happens in their life, see if they can achieve stability, and if they can, then they leave. And that it's like I suppose it's about late stage diversion. So we talk a lot about diversion in criminal justice, but we always think of that being at earlier stages. But actually, why can't we have late stage diversion as well? That somebody has made it all the way to court, but that doesn't have to be the end. And we know the burden that a criminal conviction places on people in terms of housing, jobs, all the things that somebody might need to access to get their life on track. So if that can be avoided even at that stage, then that seems to be something worth looking into. So those are just a few of the different models existing, which I think are really interesting and are worth thinking about further if we're going to be you know, if even the government are now accepting we shouldn't be sending people to prison for short sentences, then there needs to be a great deal more imagination go into the alternatives rather than just saying let's make it suspended prison sentences. Thank you.
Shona, Fiona, thank you both so much for that. They were both incredibly interesting and insightful presentations. So thank you both so much for that. I mean, I've certainly got lots of questions, and I can see that there are some coming through into the Q&A. So please do post questions in there as well, and we'll open up to some of those. Hopefully mine get covered as well. If not, I'll try and throw some in there. Okay, so Fiona, I think this was particularly when you were speaking. So Nikki had asked around, do the drug treatment services and housing in the area, in your area, also operate with women-only spaces?
In the main, yes. So we have got quite a lot of support from our local drug and alcohol services to co-locate themselves at the women's centres to see women there. We would like women to show up and get all the support in one place, the true one-stop shop. It can be a bit fragile, as a lot of the model is. So something practical could happen, like the support worker changes and it's a man, and we don't, generally have men in that women's centre, but another women's centre might have a man. So we're always sort of reviewing that, but we do try to keep everyone in that safe space. Yeah, absolutely.
Thanks, Fiona. And then there's a question from Carl as well. And Carl, thank you for being really open and sharing around yourself here as well. And Carl's saying, I'm a police officer with ADHD. And Carl's asking around the relevance of neurodivergent conditions and learning disabilities. And he's saying he knows that conditions like ADHD are vastly underdiagnosed or misdiagnosed in women. And is just interested in work that's been done around improving the recognition of ADHD, or understanding how the symptoms could be responsible for criminality and substance misuse disorder. Should we be continuing routine screening for ADHD to understand that as a root cause, or are there some thoughts you've got around neurodivergent conditions that people have?
Shona, shall I come in there, just sort of what we're doing in probation? I think we're probably playing catch up in probation with our understanding of neurodiversity. And I think we're working with people when they're in the system, aren't we? So we're working with people when they're getting sentenced or getting released. And so what I'm seeing a lot of is a lot of recognition, a lot of support, a lot of awareness of how we would adapt material for people with neurodiversity. Whether, and Shona, I'm going to look to you, whether maybe the defence community are pulling on that within court appearances, I'm not quite sure. But yeah, there's definitely a lot more that we could be doing there.
Yeah, so the Equal Treatment Bench Book, which is just an extraordinary publication that the Judicial College publish, I think it goes to something like 600 pages currently, and I don't know how well used it is. But the most recent update of it, which came out last year, has got really great information which sentencers should be looking at about neurodiversity and all of those things. Now, of course, there is the issue if somebody's undiagnosed, then that becomes, it's not easily something that can be applied if you can't have a judge or magistrate saying, well, I think this person's neurodiverse, so I'm going to apply this thinking. But I do think there is a growing understanding that, with all the stuff about under 25s and brain development that has come into sentencing guidelines, and actually a bit of a plug for the consultation that's going on at the moment on the imposition of community and custodial sentences. And the Sentencing Council in England and Wales have put out a consultation on that revised guideline with particular sections about women and about young people. And if anybody, I presume because you're here today, you've got an interest in women, I think what they're trying to do is really good. And there is a lot to be encouraged and supported. And so can I encourage you, please, to look at that consultation? Maybe we could put the link in the chat or something, and reply to it, because the Sentencing Council are brilliant at listening to the responses they get and changing things because of it, or being supported if they're going in the right direction in terms of what the evidence is suggesting. So sorry, that was just a sort of by-the-by plug for that. So I think, yes, it would be great if people, if somebody is neurodivergent, I think that should, of course, be brought to the attention of the court. I know there's been some recent academic research around people with autism going through court processes and what that does. I think we've talked an awful lot about trauma-informed practice in the last few years, but I think that has almost lost currency because it's often very unclear what that means or how that should be used or operationalized. And I think we need to keep thinking broadly in our understanding that people are all different. And in order to sentence effectively, there needs to be an understanding. And I think the big difference with problem-solving courts compared to other courts, when I interviewed magistrates who were sitting on the bench in the courts in Manchester and asked them what is the biggest difference between sitting in this court and sitting in another court, and they said, we listen. And that is pretty telling, isn't it? That it's just a shift in what is actually going on in that space. And I think that's quite key to whatever else we do. I'm sorry, that didn't really answer the question, neurodivergence, but I think it's part of the answer.
Yeah, no, that's really helpful. Thank you, Shona. And I think Miranda has already put the link in the chat as well for the Sentencing Council consultation. So please do engage with that. Is it at some point in February, Shona, that the deadline is? I'm putting you on the spot now. We'll find that out and put it in the chat as well.
It's about the 23rd, I think.
Okay, 21st of Feb. Thank you. Someone else has put that in the chat there. Great. Okay, and then we've got a couple of questions around problem-solving courts. So Rebecca's asking, where can I find out more about problem-solving courts? And then a second to that, is restorative justice an option as part of problem-solving courts?
Thank you. And I can see the Q&A tab now. I was getting very lost in the chat trying to find the questions, so I can see what I'm being asked, which is all helpful for me. Okay, so we've got different models of problem-solving courts, as Shona mentioned. More than happy for anyone to contact me directly if you want to find out more about the Greater Manchester model. We've evolved a lot over the last 10 years, so I can sort of talk you through how that's working at the moment. Restorative justice, it comes up, it isn't currently something that we have in the problem-solving court approach, but it's something that we were really quite strong at over 15 years, I'm going to say, in probation. We've had a lot of restorative justice, and we do deliver restorative justice at the moment. So I'm not quite sure why we wouldn't have it as such a key component of problem solving. It would be something that someone would do during the body of their order, but they certainly could come back to court and talk about how they're finding that to the magistrates, because the magistrates are quite keen to find out about all aspects of the requirements they're completing, whether it be a programme or something like restorative justice. So you've actually given me a good idea there, so thank you for that.
Thanks, Fiona. And at the centre, essentially, we've done a lot of work on problem-solving courts, both in criminal and in family, and particularly around women's problem-solving courts as well. And I think a colleague's putting some links in the chat again. So if you want some guides that give you an overview of problem-solving courts, where they are, how they're operating, then please do engage with those guides as well. Shona, is there anything else you wanted to add in there?
I think I would just say, in answer to the question about is there information, it is fairly sparse. And that is, so, Centre for Justice Innovation has been sort of working on this for quite a while. And Fiona's been doing it 10 years, but I think it hasn't really come out yet in a way. It's not something people are engaging with. The thing that is interesting me is seeing in other jurisdictions, particularly in the global south, where these have been going for quite a long time and operate in perhaps different ways. And I'm sort of trying to work out how I'm going to get to do work on that and go there and see more. Because I think we have an awful lot to learn in trying to develop these different modes of justice. Can I just jump in? I see a question asking about, having visited and seen the work in Greater Manchester, what learning would I direct Manchester towards to further improve the approach? Which feels quite cheeky sitting here with Fiona, but we have discussed these things before a bit. I think something for me that seems to be really important is an understanding of what is the purpose, what is trying to be achieved, what is the role of the bench or the judge in the situation. One of I think the concerns that's directed to these kind of courts or alternative justice measures is that it moves into paternalism too quickly, and it becomes about, I'm going to solve your problems for you, and I know better how you should be doing this, and this is what we're going to do. And that's all wrong. You know, as Fiona said, that's trying to give people agency in their own lives, trying to give people autonomy, trying to give people the support and the tools that they need to use to do what they want to do. And so I think that is something that is always going to be a tension. You know, and I know that Fiona, in terms of training and all those things, that is something that they're very conscious of. I think the Manchester model has some great aspects to it compared to other models. I mean, I'm not sure who's on the chat, and I need to be just careful, but and Fiona's also a civil servant. But the MOJ pilot has a difference to the Manchester model in that in Manchester, if a woman does not attend the court, that is not a breach of her order. So she can make a choice that actually she's got to go and see her child's social worker, or she's very tired from work and she can't make it that day and actually she thinks she's doing okay. She doesn't have to turn up to the court and she will not be breached. Whereas the MOJ pilot, as I understand it, they are breaching women for non-attendance. And I think that is a really, I would say in terms of the Manchester model, I think that's a good thing that they are doing, because again, we're trying to say this, your sentence is not your you know, having to complete your sentence is not also part of the punishment. So, Martin, perhaps I would speak more freely if I wasn't on a call that was being recorded about what I would say about things, but that's some things to be thinking about.
Thanks, Shona. And then there's some questions around the practicalities around problem-solving courts, such as where it takes place, who sits in them, and especially with court backlogs, and we know that that's a real issue at the minute as well. So how does that fit around other hearings and sentences that's going on? So I don't know if you want to speak to that, Fiona and Shona.
Yeah, so for the Greater Manchester model, we've got reviews taking place in 3 magistrates' courts. So we host reviews for 15 women 4 or 5 times a month, depending on the kind of frequency of reviews. We've got about 120 women coming through the courts for reviews. So it's within a magistrates' court, using one courtroom at a time, with a dedicated bench of magistrates that we have. And a legal advisor, and they're all kind of the problem-solving court specialists of being the magistrate or being the legal advisor. They're all kind of brought into the wider model. And I'm just going to remind myself of the second part of the question. Oh, the backlog. Returning after the pandemic and trying to persuade the court to give us a courtroom when there's such a backlog of sentences to be passed, and, you know, rightly so, victims deserve swift sentencing. That was really difficult, but we had over 100 women who were missing out on the review element of their sentence. And we knew at that point how successful it was overall as an order, so we really had to sort of persuade HMCTS to give us the courtroom back, which they did. And our outcomes and our volume has actually increased, and we're seeing more and more women coming through now than we did pre the pandemic that are actually being sentenced at the Crown Court. So it's worth the investment, I think.
Thanks, Fiona. Shona, I don't know if you wanted to say anything else around problem-solving courts more generally.
Yeah, I mean, I've just seen them working quite differently to the Manchester model. So in Glasgow, it's open court. It's like any criminal proceedings. Everybody who's on the list is sitting there at the beginning, and each woman is called in turn. They're much shorter. The reviews in the Greater Manchester courts are quite lengthy. I can't remember, Fiona, how long it is, if it's 20 minutes per person. Yes, 20 minutes per woman, and she's just in there with the magistrates on her own. Glasgow is more like 5 minutes per case. The sheriff has the report from the criminal justice social worker, and what they're very conscious of, because it's open court, is not talking about things in detail because of a woman's privacy, because often the kind of things that have been going on for the women in the intervening times have been really horrific. I mean, there was one time I was sitting there, and at the end, the sheriff came down to talk to me afterwards, and she said, of the women today, you know, one had been raped in the intervening time, another woman had had a partner die, another person had a son die. There's just so much going on that you can't talk about those things in open court. It wouldn't be right. And so I think there are difficulties about managing quite how that dynamic of listening can work when you still hold it as a regular court proceeding.
Thank you. And we've only got 10 minutes left, and I'm really keen to try and get through as many of these questions as possible. So there's one from Helen, which is around how much do you feel significant investment in third sector organisations could encourage more sentences to community? And Fiona, I know you've talked a lot around the support of the Women's Centre, for example, and just this increase also, I know obviously not third sector organisation, but statutory services like probation as well, and workload. And so what are your thoughts around investment into some of those other services, and particularly some of those third sector organisations?
Yeah, and I think I've already described the model as quite fragile. So even though it's been going for a long period of time, you know, third sector charities, women's centres, they unfortunately come and go. And what we've found is that through the women's centres coming together, that's become sustainable. I feel like when I describe the Greater Manchester Women's Centres, it sounds like an amazing shiny beacon. Actually, some of them are very cold church halls that we're just renting for half a day. It's the ethos of the team that makes the Women's Centre, but it absolutely is key to the success for the women. And I think that the women's teams in probation know that it's the support of the Women's Centre alongside probation that is the success for the reoffending rates that we have. So absolutely, there needs to be a huge investment across all parts of England and Wales into the women's centres. And I probably can't say anything else because I am a civil servant.
And do you think that do you think that it impacts on how sentencers might then respond to people that are coming before them in the courts if they have greater confidence? Do you think that there is a correlation there between what is available in the community and how they are sentencing?
Yeah, I think what we see quite a lot of is the magistrates who are part of the problem-solving court still sitting as magistrates across their home courts, and they're sentencing women. So what they're seeing from the women in the reviews who are relaying the success and the support they're getting back to the women's centres, they're aware that any woman, problem-solving court or not, has got the support of the women's centre as soon as they're sentenced to a community order. So I do feel like that must sway some thinking. If you're balancing out short-term custody, or the idea this woman would have this multi-agency approach in the community at her local women's centre, I really feel like that would be quite encouraging to sentences.
Thank you, Fiona. There's another question, which was one of mine, but someone's asked it, so I'm really pleased. So how would you respond to someone saying that this approach is soft on crime or not tough enough?
I think, as most of us know, actually having to confront your issues is really tough, and to deal with your life messes as they are is really tough. So I think it's wrong to underestimate what kind of courage and resilience and commitment and tenacity that takes from people. So if we're wanting tough, as in we on the outside can look in and go, oh, that's a horrible thing to do to someone, well, yes, prison is going to win that one. But if we were to say, well, actually being soft on crime means we increase reoffending, if that's what being soft on crime looks like, then we would say, well, we're getting it wrong with prison. And so we have to do things which are going to stop people reoffending. And this is that route. I mean, I think that the soft on crime thing is a bit of a red herring in a way, because it's taking a very binary understanding of justice, a very retributive situation. So if all we want is revenge and harming people, then yeah, this is probably soft on crime. But if we're looking for other things, then maybe not. Can I answer? Fiona might want to add to that. Sorry, before I say something else.
I agree. I think for me, it's key to look at the root cause of the crime to resolve that crime being committed again. But no, I fully agree, Shona.
Thank you. Shona, what were you going to say?
I was just going to address, there's a question about, is there anything outside of problem-solving courts that is good practice? And yes, I think there are other alternatives, and we actually didn't touch on that. So thank you, whoever asked that. I just am quite, excited by problem-solving courts, so I was happy to go in that direction. But one of the things that I think is not used enough is deferred sentencing generally, whether there's a problem-solving court or not. So in the original research I did on maternal sentencing, I interviewed crime court judges, and I had one judge in my sample who used deferred sentencing quite a lot with women, and he thought it was great because a woman would come in front of him and they might have got a community sentence, they might have got a custodial sentence, but there was clearly something that they might be able to do to change their life, that they were motivated to do or wanted to do in that time. So quite often it was around addiction. And his approach was to say, all right, you're saying that this is what you want to do. I'm going to give you 3 months, and then you're going to come back and we'll see where you're at with that, and then we'll sentence. And he found that very often it was successful, that somebody would deal with whatever it was they were dealing with without it being a problem-solving court approach or anything else, but just giving a bit of time between conviction and sentence allowed people, again, agency and autonomy. So I think, and then a lesser sentence was necessary, because actually if what you're trying to do is deter, or maybe the conviction was already the deterrence for a person. So I think that is something that can be used. I think community sentences are often very positive and very effective. I just am always conscious that we need to not see them as being a lighter thing, a less difficult thing for people, or something that feels less punitive, because I think they can be very hard, and sometimes they're incredibly restrictive, and people find it very hard to continue with their life with those. So I guess I like suspended sentences when used properly for sentences that would be longer. I think that's good practice, and I think deferred sentencing is good practice.
Thank you, Shona. Fiona, last sort of minute or so, is there anything else that you would say there around other approaches that you think are helpful in not problem-solving courts?
Yeah, and I think we've automatically gone into problem-solving court, haven't we, Shona? Because that kind of it's something different. It's a different offer at the moment, but I'm very sure that a lot of the women that are on the community orders in Greater Manchester, whether it's problem-solving court or not, it's all about the co-location collaboration with a non-statutory support service. So for me, you don't need to have a problem-solving court. Other areas have got whole system approaches, and they work really well when they've got that kind of community link there. And a lot of women that are sentenced problem-solving court don't find the reviews as valuable as others. So it's not one size fits all. It's always key for me to have that local link for the Women's Centre in order to have a successful outcome for women.
Great, thank you. I think we've got, I'm just going to throw this one last question in there. We've got about a minute for you to answer it though, so it has to be really brief. But so Mel's saying that she often finds there are too many professionals involved with one person. Is there any scope to develop professionals so you've got one professional working with those more complex cases?
I'm just going to I'm just opening the question. Sorry, it was a bit slow for me then. Yeah, so I think for the probation professional then who's allocated the case as the statutory case, we often are maybe delegating or signposting people to other agencies and other support workers. I do think that we've managed to find our way with this a little bit in Greater Manchester, potentially because the women's centres can absorb quite a lot of the emotional well-being, financial support, debt advice needs, and the probation practitioner maybe is then just having oversight of attendance and compliance. But yes, if everyone is trying to get that woman to attend 3 appointments on the same day and her priority is to see her children, we're not going to win in that situation, are we? So there definitely needs to be some kind of streamlining of support services there.
Thank you. Thanks, Fiona. Thank you both for what has been a really interesting and insightful hour with you. I think we could easily have gone on longer, but unfortunately we'll need to cut it here. The Centre has also produced some briefings on presumption against short sentences, which you can find, so we can send those round as well. But again, just thank you so much for your expertise and for sharing your time and insights with everybody. Take care all.